Wednesday is the day the defendants in the Georgia racketeering case are scheduled to be arraigned. Of the 19 charged, a full dozen have already waived their right to appear and entered a plea of not guilty. Not on that list, Donald Trump's former chief of staff, Mark Meadows, former Justice Department official Jeffrey Clark, and Trump lawyer John Eastman. Those three and four more still need to appear or skip that appearance and enter their plea. Joining me now is former Fulton County Public Defender and former Assistant District Attorney, Chandelle Summer. Chandelle, thank you so much for your time today. Maybe a bit confusing. The law is somewhat unique in Georgia that you can actually waive your arraignment. Can anything be read into the fact that so many have chosen to do that?
Good evening, Julie. The law in Georgia that allows for the waiver of arraignment is simply a convenience for most defense attorneys, and I would say in the majority of cases, defense attorneys waive their client's appearance at an arraignment and just ask for 10 days to file motions. In this case, obviously, Trump wants to avoid any more media attention, so the idea of waiving an arraignment was certainly very convenient for him.
Well, what about Mark Meadows? He's still trying to get his case moved to federal court. So if he were to appear in court Wednesday, would it have anything to do with that? Or do you think he'll succeed in actually getting his case moved?
Well, we're awaiting the judge's ruling on the removal petition, of course. And I think he has a very strong removal petition because he's claiming that he was acting within the scope of his federal responsibilities when he was basically taking orders from Donald Trump. And certainly the president has an obligation to ensure that elections are run in a way that is accurate and fair. So under 18 U.S.C. 1080, the federal court has jurisdiction to delve into whether voting systems are accurately maintained, and that includes the computer systems like the Dominion system here. So I think he has a very strong federal removal claim. However, it's interesting to note that in Donald Trump's case in New York, the one based on the hush money allegations, he asked for removal to federal court and it was denied.
So let's talk about Fani Willis. She is still taking heat from Georgia Republicans. What can you tell us about a new law that could have her removed for bringing the DA's office, quote, into disrepute?
Yes. Okay. In the last legislative session, the Republican-controlled legislature passed a new law that appointed a 5-member panel called the Prosecuting Attorneys Qualification Commission. And they have very broad powers to remove district attorneys from their positions based on conduct which they believe brings the office into disrepute or is prejudicial to the responsibilities that they have as a district attorney. And clearly there's a movement underway to have Fani Willis removed from her position as a district attorney. It's likely to be unsuccessful, and that particular statute that was passed in the last legislative session is currently on appeal. There's an injunction that's been issued based on an appeal by 4 different district attorneys in the state. So they are claiming that it's a violation of the separation of powers doctrine, and that, in my opinion, is likely to succeed.
It seems like that would just be such a hard thing to prove. I don't know. I'm not the lawyer, but that just seems like it would take time to prove something like that.
To prove that someone is acting in contrary to their responsibilities. Yes, it's very broadly worded, which is part of the problem with the statute. You can't have something that's not specific as to what you're doing wrong. Otherwise, it just leaves it to the whim of political processes. So I think it's likely that the statute will be struck down. So she doesn't really have anything to worry about in that regard, in my opinion. However, there's also a movement underway by the House of Representatives to have her office defunded, which I think also is unlikely to succeed.
Okay. Well, let me ask you then about the big question around all of this. Are any of the lower level defendants in this case going to flip? What is your sense of that and what that could mean, and what would be the timing on something like that?
I think that there's the possibility that Mark Meadows might flip. He's the one who is closest to the president and certainly has a lot of inside information, and he seems very interested in his own fate. The other particular defendants, they certainly all have incentive to flip because there's jail time that is likely to occur if they don't.
And money and legal fees, right? The legal
fees and money, which I think are less concerning to them, because I think the MAGA Inc. comment that Jenna Ellis made on Twitter is probably resonating, and they're likely to be funding the defense for all of these individuals. But it's interesting to me, it's almost like a capitalist society within this group. You've got some people who are still, in jail for longer, like the people associated with the Coffee County allegations of influencing, trying to influence the women who were the voting officials or the elections officials. They don't seem to have the money or even the bond set before they turn themselves in. So it's an interesting group of people.
We shall see. Chandelle Summer, thank you so much for your time tonight. We appreciate it very much.
Thank you, Julie.